Hi all, my name's Tom and this is an update on the court cases we've been going to just recently, and I do apologise to all those that's been following us. We couldn't put out all the information. We're having to cover our tracks because of agents and also quite nasty individuals that's trying to disrupt court cases and also give out misinformation to the general public. Try to blacken our names. Now, for all those that haven't seen our videos, go to our, or don't know our story, go to our YouTube channel, watch video 1, and then the following ones I'll give you a good insight exactly what's been happening up to date. But to tell you what happened on the 2nd of July, approximately 200 police, 21 riot vans turned up, 3 armed response units, dog teams, 40 to 50 bailiffs, helicopters, an ambulance, and also the fire station informs us that a vehicle was put on standby in case it was needed. Any right-minded person would think, wow, they must be extremely dangerous, these people. Well, it's just myself, a wife and my daughter, and they were coming to take a 2-bedroom house. And yes, we are extremely dangerous. We are extremely dangerous to the banks and to the courts. We've been giving out information to the general public that was meant to be kept very secret, especially the court information. In fact, it's so affected them that they've had to change their motive operandum. They've been, that's the way they do business. You normally go and you try and get your documents or file documents. You can't do this in London now. They're shutting down all the county courts and you put it in a letterbox because they don't want even to get their Mickey Mouse stamp off them, which is a really false stamp. It's not a real seal. Now, take you more up to date with the 3rd of September, when we were in court, we placed in front of a judge who was a substitute judge. Our judge was removed deliberately and a gatekeeper judge was put in his position. This judge went immediately on the attack of myself regarding third parties, and then we found out that that was his speciality. I'll tell you more about that in a moment. Now, I placed before the judge information. I said, you cannot rule in this case and kick it out because it doesn't have merit, because I'm putting facts, not hearsay evidence. I know they allow an amount of hearsay, but when facts are presented, it overrides their hearsay. Number one fact, the bank, Bradford and Bingley, never paid a fee into the court to start the whole procedure. Now this, please remember, this is very, very important. They never paid a fee to start proceedings against my wife and myself. Number 2, they never produced any accounts to prove that we've got any debt owed for them to come and take our property. Well, even if we did have debts, they're not allowed to take the property, they're allowed to sell it, but you'd be a sitting tenant. But the other thing is, they can only take a mortgagee's property if there are arrears, and this was confirmed in every court case that there wasn't any arrears apart from the first one in 2012 where I got, on my wife, 3 payments behind, and we cleared that before the next court case, so there was no arrears, so they couldn't have taken the property. But that aside, we didn't go down that route at all. We went down the evidence, no fees, no accounts. If we were in debt to anything, it was their duty to present it in front of the court. This they failed to do, and this they they continue, with the assistance of the court, to avoid. Now we've got a letter from the County Court in Nottingham stating that they have no evidence that a fee has been paid. Neither the court nor the bank have produced an evidence, any evidence that a fee has been paid. Now it's very important that, and I'll tell you for why. I'll put my glasses on for this. Practice Directions 55.5 in brackets 1. No step may be taken until a fee has been paid. I stated this to the judge, and the judge said it's his court and he would allow it anyway. And I'll tell you why he is allowed to allow it. And then under CPR rules 3.7, the court will serve a notice on the claimant requiring payment of the specific fee in relation to the fee order. The claim, and down at I in brackets, the claim will automatically be struck out without further notice if a fee has not been paid. There is the directives for them to pay a fee. They didn't pay a fee. It was the simplest thing in the world for them to turn around and present a payment for a fee. In fact, I gave them a document to sign under their own personal liabilities. The barrister representing Bradford and Bingley, and he refused, and the judge said I can't make him sign it. Because he knew, I knew, and the barrister knew that there's never been a fee paid. It should have been kicked out then. I asked them to produce the accounts. They refused again. So we produced the facts. They went on hearsay, and lo and behold, the Judge Phillips, said our case had no merit. And in his face, he looked embarrassed to be uttering these words, and he should be embarrassed. And then Bradford and Bingley solicitors proceeded to put a restraining order against me, piggybacking my claim with an N2444. Now, this was only a draft application, it wasn't sealed, and it was to have a restraining order put on me so I could put no more claims into court in case I upset them. Very, very unfortunate. They tried to tie me to a point where I no longer can get into court to attack them. But they failed in this because the judge aided and abetted a criminal offence in that court in allowing Bradford and Bingley to put a draft order into court on an unsealed document and not allowing me the minimum of 14 days to put in a defence. You're allowed to defend yourself in any case, and if I'd applied I could have got 28 days like they did. So in the future they intend to use this, but we've put documents in to stop that. Now we go on to the next case. I've been in court and we've got another claim in, a claim that they didn't put a defence into that court case I was just talking about. This is very, very important, and I'll tell you why. That's the document. I've covered up the actual date and time for it because of unscrupulous people that are willing to lie and cheat you, the public. Everything I say is documented. That was a claim that I put in, which is that's a notice of issue for a claim form, part 8. When I came before the judge, he agreed. He said there was a case here, and if it had been money, he would have simply stamped the order and it would have been done. This is an administration. It's not a proper court hearing. So it will be going into administration very soon. Now, I'll show you the evidence. This is an acknowledgement of service from Walker Morris, which I consider a criminal entity representing Bradford and Bingley PLC. That shouldn't even be trading because they're a defunct company. There's more crime going on than meets the eye, I'm afraid. Now, down at the bottom, tick the appropriate box. 1. I intend to defend all of this claim. They ticked it. On the right hand side of that claim, of that acknowledgement, if you file an acknowledgement of service, but do not file a defence within 28 days, they actually got 28 days, they were only supposed to have a very short time, which stretched to 14, but 28, judgment may be entered against you. Okay. So, now you know it may go against them if they didn't do it. So, here we go. Service has been filed. Okay, this is coming from them, and it says the defendant filed an acknowledgement of, it actually came from the court, but the defendant has filed an acknowledgement of service on the 26th of August. Remember that date, 26th. The defendants responded to the claim indicating an intention to defend all of the claim. So we put our claim in, they are going to defend all of it. The defendant has 28 days from the date of service of the particulars of the claim to file a defence. So they're going to defend it. The only problem is, a long time after all that, on the 13th of October, I filed this in the court, plus all those other documents, and I checked with the court over the coming of the previous weeks, has the defendants filed a claim, and each time they told me no. So this was the last one. It said, "Dear sir, thank you for your email. No defence has been filed." Court stamp. Into the court. Off we go. We are now in front of a judge. This isn't for a proper hearing or a trial. This is simply administration. Did you file a defence? No. Then you've lost. And the reason why they've lost is the meaning of a default judgment, 12.1. Okay? In these rules, default judgment means a judgment without a trial where the defendant has failed to file a defence. A default judgment means you've won. That's it. End of matter. They can't appeal. They can't put the defence in now. They've had plenty of time. In fact, they've dishonoured the court as well. Conditions to be satisfied, down the bottom there, quite clearly states where an acknowledgement of service has been filed but the defendant has not filed a defence.